invite comments from members as well. I just briefly had a chat to my deputy chair, but could next Wednesday, would that suit people? Come back? Would that convenient? It's a very bad time, yeah.
Well, Mr. Chair, I would say that we can't do it properly today. Mr. Thorne goes away at the end of next week, so we effectively either got to meet later this week or next week.
Just for Mr. Thorne.
But no, for both. Well, we could try and deal with all witnesses. Look, I thought we could, my fault, I thought we could shortcut it, but maybe we'll just have to have a discussion because we know Mr. Thorne's movement, so we'll just have a discussion in committee at the end of Mr. Stevenson's statement, and then we'll get back to you.
Given that it's not really particularly type of questions, it's probably require hearing from Mr. Stevenson.
That's what I was going to suggest. Great.
Thank you, Mr. Chair.
All right, now I emphasise Mr. Stevenson that read the submission, so you can take it as read, but you're more than welcome to make any additional comments or provide a summary or whatever.
Thank you, Mr. Chair. Good afternoon, I'm David Stevenson, I'm the Acting General Manager of Parliamentary Service. By way of statement, I wish to make the following points. First, it's important to understand that as a service, we received and dealt with 4 separate requests of information relating to the Henry inquiry. These requests are set out in my submission. Secondly, it is important to note that each and every one of these requests, the decision whether to comply with them was rightly made by the General Manager of the service, who at the time was Mr. Thorne. This was despite the fact that, as Mr. Thorne has said, at no stage did he receive any communication directly from the Henry inquiry about the terms of reference, the legal status, or the nature of the information needed. Thirdly, the requests were not and were never regarded as legally binding on the service. For each request, therefore, as he has said, Mr. Thorne applied the fundamental principle used by the service in its role as the provider of ICT and security services to the agencies which occupy parliamentary precincts. That principle is that the service holds members and ministers' information as their agent, either directly through the Ministerial Services and Secretariat branch of DIA, and that must be not used, and that information cannot be used in any way without the express consent of those individuals. Mr. Thorne's decision were that he would not allow any members' information to be released to the inquiry unless he could be satisfied in each instance that such authority existed. He required the equivalent authority for ministerial and support services in relation to ministers' staff on the basis that they are DIA employees. Where he was not satisfied that such authorisation existed, Mr. Thorne directed that the inquiry's request be refused. That wasn't the case in respect of the first 2 requests until appropriate authorisation was provided. The third request, insofar as it concerned Mr. Dunn's emails, and the 4th request in respect of Mr. Dunn's swipe card usage. Fourthly, the factors relevant to the inquiry's request for Ms. Vance's building access records were different from those relating to the information held on behalf of members. Ms. Vance was not an MP. As Mr. Thorne has said, his decision on this request came under his ultimate responsibility for security on the parliamentary precincts. His decision that that requested information should be given to the inquiry was made in the exercise of that responsibility. Fifthly, the service knows that its implementation of its General Manager's decisions on the 2nd and 3rd request, that is, the requests for the phone records and the content of Mr. Dunn's emails, was less than adequate and resulted in a mistaken disclosure of information to the inquiry. The information that was wrongly disclosed can be described in simple terms. First, records from the Fairfax Media Parliamentary telephone extension used by Ms. Vance, showing calls to and from the extension, in addition to the records from ministers and staff members' telephones, which authorisation existed, but for which no data could successfully be extracted. Second, an electronic file containing a number of Mr. Dunn's emails, which was not removed from a larger zip file containing ministerial staff emails and was sent in error to the inquiry administrator. The error was picked up immediately and the inquiry administrator was contacted before he had an opportunity to open the file. He undertook to delete the file, the email was recalled by the service, and in any case he later found that the zip file had been sent in the form that the inquiry could not open. Sixthly, the service accepts that these two errors occurred because of inadequate oversight of staff, including the Datacom Wellington staff, who were given the rather difficult task of extracting the phone records that would be sent to the inquiry at Mr Thorne's direction once he had received the necessary authorisation from ministers and DIA to release them. The service accepts that errors can undermine confidence in its role as a custodian of parliamentary information. The service apologises to those concerned. Seventhly, and in the service's defence, it needs to be understood that the task of identifying and extracting information for the inquiry, particularly in relation to the metadata of the phone records, became protracted and highly complex as a result of repeated requests and refinements received from our staff by the inquiry administrator. The task was also unprecedented. None of this metadata had ever been analysed before, for the simple reason that it